We are excited to have everybody here for our revised, expanded Force in the Fur Missile. We had the Supreme Court was kind enough to give us some good case law that gave us an opportunity to expand on what we're talking about. We have Mr. Matt Rook back again. Excited to have Matt. And for those of y'all that were not able to download the last episode, it gave us an opportunity to do another one, but it's proof of one thing. Do not let Lance near the technology. So if you're wondering, that's a really good guideline to have. Always keep somebody between me and technology. So Matt, why don't you go ahead and introduce yourself, and then we'll get started. I'm Lance LoRusso with the Blue Line Lawyer Institute, and Matt Rook is with Hurricane Creek Kennels. He's going to be helping us out today.
Hey everyone, my name's Matt Rook. I'm with Hurricane Creek Canine in Carrollton, Georgia.
Matt, you're muted.
How about now? Can you hear me now? Can y'all hear me?
Yes.
Okay. Let me grab my other microphone because my earbuds failed me. There's me and technology.
All right. So, well, Matt is grabbing his microphones. The Blue Line Lawyer Institute was created a few years ago to be an outlet for law enforcement officers and the attorneys who represent them as a think tank. So we bring issues to the forefront and that affect you on a regular basis. Quite frankly, a lot of the issues we bring to the forefront were brought to us by the public and their complaints about law enforcement, or by law enforcement saying we need training in this area, or by us watching the courts and seeing what is relevant for our folks, what is affecting our people. Matt, how are we doing now?
Can y'all hear me better now? Can y'all hear me now?
All right, Matt, go ahead. They can hear you.
Okay, cool. We're doing better now that my technology works. Yeah, I definitely think one of the areas that we fall down in canine as a whole is that we don't get a whole lot of training depending on where you go to canine school and things like that. There is no standardized training. So keeping up with these case laws is pretty much left up to us. Or if you have a good kennel, they're going to email this stuff out to you. But yeah, the more and more that we're seeing, and a lot of the stuff that we see on our private side, it's getting very litigious when it comes to canine use of force the farther we go on. So these things are things that you guys really, really need to pay attention to. You really, really need to work them up your chain of command. If for some reason they don't agree with them, call me. We'll talk to them, because sometimes we can say things that you guys can't. So
yeah, it's part of not having a chain of command. Tell them a little bit about your company and your nonprofit.
So Hurricane Creek Canine, we started about 4 years ago. I spent 20 years in policing, 15 of that in canine. I wanted to do it different from any handler schools and any type of dogs that we'd ever done before, as far as structure the class better, make it more law enforcement specific, get you guys out in real scenarios, live stops, things like that. While you're in training, we do a lot of night training. So the first time your dog and you work together isn't at night. So we did it to kind of disrupt and break the mold. And it's going well so far. We also have a nonprofit foundation for underfunded agencies where they can come through our program, and we can get them a dog. One, we can help you basically crowdfund or raise the money, because we have our nonprofit, so we can help you collect tax deductible donations towards your program. The other thing that we can do is, if you're an underfunded department, we have programs where we can get you a dog for significantly less than you would pay at a different kennel. And we stay with you through the life of your dog. If you need something, you can always pick up the phone and call us, and you'll get a master trainer. So again, we want to do it different. One of the big things that we focus on in all of our classes is case law and using the dog in the proper context, and to really think about how you're using your dog and the ramifications down the road, whether it be from the criminal side, the civil side, and making sure that you can prosecute your case.
So, Matt, appreciate that. And all lawyers are supposed to have a disclaimer, so we don't want to disappoint anybody. So if you'll forgive me for a moment, Barbara, who we want to thank her for her efforts, she is behind the scenes. And here is the disclaimer. The information provided on this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for general information purposes only. Any references to state law are for illustrative purposes only. You should contact a licensed attorney in your state to obtain advice with respect to any particular legal matter. I am licensed to practice in Georgia, Tennessee, and Arkansas. I'm also admitted in a lot of federal courts. So I have a case in Michigan right now, another case in Alabama, where I've been brought in by some unbelievably capable counsel to help them out. All right, so Matt, when we talk about use of force, and one of the things that we run into all the time is this concept of the canine as another tool on the belt. Now, obviously, it better be a pretty big belt if you're going to carry a Malinois around with you, although that might be kind of cool. But, if you can talk a little bit about that, about training canine officers to recognize, especially the new ones, how do you get across to them that you now have a whole other avenue, a whole other way to perform your job, but recognize that new opportunity also has the capability to use force?
So one of the biggest things that we try to get through to these new handlers is when you stepped into law enforcement, you took on an awesome responsibility, and you also took on an awesome liability if you do your job wrong, and this host of other things that we all know. When you get into canine, you're doing that times 10, because now you've got a partner who can't speak and tell you anything. They can bark at you, but unless you speak dog, you don't know what they're saying. So, if you know how to speak dog, please come tell me, because that would be great. But in that,
I want one of those too.
yeah, right. But in that, you have to account for the things that you see. So let's take a simple canine demo, for example, because a lot of departments these days are really big on having social canines, having them out in public and things like that. Um, as a patrol officer, you look at it and you're like, oh, hey, the dog guy's got his dog out. Cool, look at him. There's so much that went into getting that dog to be comfortable in that situation and things like that. But there's also, you know, the tips and tricks that we go through. Look, if your agency's going to have you out in a PR situation, put a toy in the dog's mouth, because if the dog has a toy in its mouth, it's less likely to want to put somebody's arm in its mouth. Doesn't mean that the dog's violent or anything like that, but you have to think about those things, because the minute that that dog bites an innocent citizen, you've got liability, you've got lawsuits, you're in trouble, even though it was your dog that did it. But at the end of the day, they're the ones that put you in that situation. So we try to get them in the mindset of thinking that you're not only thinking about your actions, you're thinking about your dog's actions. And think about what you can do in these situations. Think about what your dog can do in these situations that you're going into. And sometimes the answer isn't always to use your dog in a use of force situation. These days, we're seeing bite ratios that have gone down. Back in the day, you had dogs getting 15, 20 bites a year, if not more. My last dog that I worked in Metro Atlanta, county of 900,000 plus, we had 2 street bites. Does that mean that he didn't have the opportunity to bite more people? No. What it means is that being thoughtful about your deployments and being thoughtful about who actually needs this force applied to them goes a long way. So bite ratios have gone way down. A lot of people could argue now that there's body cams, that's part of it. No matter what it is, nobody wants to get bit by a dog. So
Yeah,
think
I think
about
one of the issues I want to talk about with that is it's another arrow in the quiver, but it's important to look at how the law examines that arrow in the quiver. And dog bites create nasty wounds. The dog bites are not good to look on look on TV, and especially on body camera and video. But the bottom line is, at the end of result, and the courts have looked at this over and over again, a canine apprehension by the use of a bite is going to be non-deadly force. And it's non-deadly force that's transmitted by the canine officer making that decision. So as you and I have talked about, and we've talked offline, we talked today, we talked before the first seminar, and you and I have known each other a long time. this whole interplay between the decision making of the handler and the decision making of the canine is one unit, but the handler is a whole lot more predictable and a whole lot more subject to intervention and reason and changing circumstances than the canine, where the canine is going to be making a decision on what they have in front of them, and second guessing that becomes problematic. One of the things that we talked about was the cameras on a dog, and we talked about the last one. We had some good feedback on that. You want to kind of give your 2 cents about dogs carrying cameras on their heads?
So it's the same thing that we ran into when we saw body cams come into policing. You know, very few of these are actual point of view, where the officer's head's turned, where the officer's looking. Even then, you can move your eyes independently of your body camera. So one, you're going to get an unfair shake if you go to try to stick a camera on a dog. I mean, I get it. Everybody wants a camera on everything these days, but you're not going to get the true picture. All you're going to get is this dog going up, the perp screaming, and it's going to look horrible in court. You know, it's not one of those things. I think that we have to step back and we have to realize as a profession, sometimes having some of the coolest stuff isn't necessarily needed. And number two, in this instance, I think that if you try to stick a camera on a dog, that it's not going to go well. You're not going to get a good application. All these handlers in here would tell you your dog's going to throw the camera off, because I'm sure at one point or another, some of y'all have tried to stick a GoPro on your dog. It doesn't work real well. You get a bunch of bouncy footage. You get a headache looking at it. So again, I don't know that a whole lot of good comes from that. I think that focusing more on how you read your canine and how you work together as a team and applying your knowledge of your dog in certain situations is going to be the best tool to keep yourself out of a use of force situation that's going to get you hemmed up, if that
Yeah, and
makes.
let's throw something else past there because I think you're spot on about the mechanics. I mean, look, we have 2 dogs and we try to dress them up for Christmas. They don't even want to have their elf hat on. I can't imagine. And they're definitely, they're English labs. They're not high-speed dogs. But the other issue, the disconnect that we have in the courts, and we're seeing that in criminal courts, we're seeing it in civil courts, we're seeing it in media response, the public has a disconnect between what the officer actually is seeing in a true use of force situation and what they see on TV or in a movie as being a mock use of force situation. So, one of the examples I love to give, if you're in law enforcement, you love Clint Eastwood movies. And if you love Clint Eastwood movies, you love The Good, the Bad, and the Ugly, and A Few Dollars More, and A Fistful of Dollars. Sergio Leone, we've all seen those movies. Sergio Leone was not allowed to show any blood. So if you look at the movies where somebody's shot, now there's people got beat up, but if somebody got shot, there's no blood. And we accepted that because it was a movie. So you take that whole dynamic where people are still really in shock and still trying to adapt of this video medium that they weren't prepared for, actually showing somebody fighting with an officer, running from an officer, pulling a weapon. And then you put it to a perspective that they have no way of understanding, which is a camera that you somehow managed to get on a canine. And, sooner or later, someone's going to come up with some sort of a device that's small enough that a dog could probably wear it. But I will tell you from a legal perspective, I think it's a nightmare. I think it's a bad idea. And in a way, the dog is reacting to the circumstances at the time they deploy. And as you and I talked about prior, we know from these situations that people's perspectives, the suspect's perspective, the person being tracked, their perspective, I mean their physical relation in space changes. A person can change 90 degrees position in a third of a second. So when the handler makes a decision to deploy the canine, by the time the canine covers that 2 or 3 strides, that suspect could be in a completely different perspective than the officer believed they were when they deployed them. But unless something significant happens, the dog's not going to make a different decision than the one they were trained to make at that point.
And to interject, I mean, every one of you guys out there, guys and gals out there that certify with NAPWADA or NNDDA or any of these certifying bodies, your dog has to recall. Now, the reality is, and we all know it, and we've all worked with dogs like this. We've all had partners that had dogs like this. The recall is one of the hardest things for some dogs, and you get them through certification, but at the end of the day, unless your dog pops its air brakes every time, no matter what, be very sure that when you send that dog to go bite, that it is intended to bite somebody, and that you got your your explanation, your justification, because training scenarios are one thing. Train like you're going to fight. Train, do some real life training, and make sure that if you're going to release your dog from a distance, that they're going to recall in a real situation. Because again, we all know you go to certification, you've got to do it to pass certification, but we all also know which one of our dogs we believe will do it in the field, and which one of our dogs we know that when we let it go, we better make sure that it's a righteous bite, because that dog's not going to turn around. And that's just the cold hard reality of this, if we're all talking facts here. So these are the things that you need to keep in your mind. It is,
And while we're on that, you mentioned certification versus training. Let's talk about training, and I'll throw this out and kind of start this topic here, because you're the expert on training canines and how often they should train and different issues, and I'll prompt a little bit here as we go. But the courts have basically gone back to the Canton versus Ohio and the Harris case. The question is, was the training appropriate? Did it fit the circumstances? Was it realistic? Was it constant enough to give a guideline to what the officers had to provide? Anybody in training has seen the Harris case. But over and over again, when there's liability for a canine in an agency, especially under a 1983 case, they're going to go back to that training. And was the training realistic? Was the training based on what you're seeing? Was the training of not only the handler and the canine progressing with standards, not just the standards of the law, but with other technology that's available? So how often should people be training with their canines? If you could talk a little bit about training with multiple groups, training with other agencies, because and as a handler, you were with a small agency, a couple of small agencies at times or another. You were called to go assist with an agency. You may never have even known anyone there.
yeah. So, the Supreme Court, the last thing they really said about canine training in a number of hours is that it related to patrol dogs, and it's that you need to have 16 hours of training a month. Okay. Um, you have some agencies with their single purpose dogs, they're lucky to get 2 hours a week, 4 hours a week. Some of y'all out there probably going, I got a dual purpose dog and I only get to train every once in a blue moon. Look, train on your own. Do what you have to do. Do it later on in the evening when there's not a whole lot of calls. Get somebody to lay you a track. Get somebody to take a bite, because at the end of the day, the department limiting you on your training down the road is going to get you into an incident where you're like, well, the department wouldn't allow me. That's not going to fly if you end up in federal court. So again, minimum the Supreme Court says is 16 hours a month with a patrol dog. I would recommend, if you can get 6 hours a week with a single purpose, and if you can get 8 hours a week with a dual purpose, you're going to have a good dog as long as you're training correctly. Train with other groups. Let a lot of larger agencies, they stay and they train with their own groups because it's a logistical thing. If you're on this and you're running a canine unit, I challenge you to let your handlers, maybe not all of them at once. If you can, good. If you can't, okay. But every once in a while, let them go and get some experience in different training groups, because if you train the same way every time, you're going to get the same results. If you go to these other groups, your handlers, and for you handlers, encourage your supervisors to go to these different trainings, to your trainings, to everybody's trainings, because you're going to see different things in different training groups. It's going to be like when you rode FTO. Some's going to be good, some's going to be bad. Take the good, leave the bad, make it your own style, but branch out and be around the people that you have, A, the propensity to work with, or B, we've all heard, hey, so and so's got a great canine unit. So and so's got a great canine unit. Go train with these folks. Look, anybody in here that can get to us, you're more than welcome to come out to our facility and train. We're not going to charge you. That's not what we do. We want to make the profession better. We want to make the craft of canine better. But get out and open your eyes to different training, because a lot of groups that I've gone in and out of, one of them is, hey man, the most important thing at canine training is where we're going to eat. Once we've solved that, the next thing is what problem are we going to solve with dogs today?
Yeah,
Because inevitably,
well, and let's talk about this real quick too, because it's not just training with other handlers. I mean, you typically wind up in situations. I mean, when I think of canine deployments, I think of tense, uncertain, and rapidly evolving circumstances. And if that sounded eloquent, I stole it from Graham versus Connor. So, but that's really what you're walking into. And we're going to get to Barnes versus Felix in this regard, because we talk about totality of the circumstances, and that case was about the moment of threat doctrine, and we are going to have some case law in a second. But training with other TAC units, letting them see how you react. What did they need to do to set up? What does a perimeter really mean when you have a canine in there? How do you set it up differently? How do you deal with a barricaded subject differently? And how can the dog assist? And then I think another thing, and I'm going to lawyer up here, not only have the sergeants, but you know what? Bring your lawyers. And if they tell you they're too busy, you need new lawyers. They need to come out and watch this stuff. I've watched SWAT teams drill. I've watched canines drill. I've watched just about every type of training. And I'm still sworn, so I wind up being on the inside of a lot of that. But the time for them to figure out exactly how you do your job, and I'm just going to say at full speed, is more than just watching somebody in a red man suit on a video that happened to be captured during the training. Being able to see what it's like at the end of that track when the canine officer is, as we say in the South, whooped. And why didn't you write a report at the end of your shift? Because I had nothing left. I couldn't hold a pen. I was done. My dog was done. It was especially in the Georgia heat. I needed to get them to cool down. I needed to get myself to cool down. So a lot of the reality is what we talk about it. And I want to move on to some case law here for a second, because we talked about Graham versus Connor. And I'm going to go a step further. We have everybody here is a law enforcement officer, and Barbara's going to pop that slide up for us. If you do not read Graham versus Connor once a year as a law enforcement officer, then I would like you to do an exercise. Raise your arm above your head, bend your elbow, and smack yourself in the back of the head. Please do it a few times. It is an amazing decision. It has been quoted tens of thousands of times because of the way that it's written. 1989 decision. Some of you probably were not alive in 1989. And Graham versus Connor was really was a use of force case, but it was also a case about law enforcement perception and how the courts are going to judge law enforcement perception and law enforcement officers acting in those circumstances where they are called. They do self-initiated activity, and their duties require them to take action. They don't have the luxury of sitting in the car and saying, well, somebody else will handle this situation. So Graham versus Connor talked about those Graham factors, the severity of the crime at issue, whether the offender is endeavoring to escape, whether or not there's an immediate threat of harm. And Graham versus Connor talks about a few things, not judging the officer in hindsight, judging the officer's actions from the perspective of a reasonable law enforcement officer, not a reasonable person. So these are keys that are important to not only remind yourself of and not only review, especially if you're a trainer, but also just to be able to articulate in some of these situations. And, one of the things Matt and I were talking about offline was some of the criteria, and we're going to get into that in a second because I want to get to Mendez first. But some of the criteria that are being used in whether or not you call a canine are getting back to these Graham factors. And there's a lot of controversy right now as to whether or not these Graham factors will be used with regard to civil cases. But it's all based on the training and what the officer brings to the scene. And talking about bringing to the scene, if you've never read City and County of Los Angeles versus Mendez, I would encourage you to do that. That case has come to the forefront And I'm going to predict that in the next 5 years, it is going to come to the forefront even more based on Barnes versus Felix. LA County versus Mendez is a case where the United States Supreme Court, dealing with a case out of the Ninth Circuit, rejected the concept of officer-created jeopardy. Now, I am defending criminal cases. The only criminal cases we handle are use of force cases. And I am defending cases, murder cases, where the prosecutor is saying, well, if the officer had acted differently, the suspect would not have had a chance to assault them. Therefore, the officer's use of force when they were assaulted was unlawful, which is, I'm trying to think of the appropriate legal terminology for that, nonsense. And Matt knows me. He's actually probably happy that my description didn't start with a B. So it's nonsense. But in Barnes versus Felix, that exact issue came up, and the court rejected again the officer created jeopardy standard, but it came up and we are going to see it again. So, Matt, can you talk a little bit about the circumstances that are used, the criteria that are used around the country, and now how this is morphing and when we're going to use canines, when we're not? You know, we just had some civil unrest in Los Angeles and other cities, and the perspective of when you can use a canine to control a crowd as opposed to doing a track, and not just a track for a suspect. You know, people forget that you go look for lost kids and disabled adults and elderly folks.
So, a large trend that we're starting to see in the canine training world is you have a lot of departments that are going to tracking for felony only. You have a lot of departments that will leave it up to the handler based on the training, based on things like that. I will interject. Look, if your department allows you to be the one that makes the decision if you're going to track, irregardless of what it is, whether it's a missing person, a juvenile, a felony suspect, train in such a way that you know your canine's not going to nuke somebody at the end of that track. If you always train to a bite at the end, don't expect your dog to find the person and then wait for you to tell them what to do. So a lot of that's based on training. A lot of that's based on things way above our heads, way above. If you're talking in the legal offices, they say, hey, we're only doing this now. We're only doing that now. Again, train like you fight. But I was talking the other day with an agency, and I really thought that this was a unique approach, which was Graham factors. Use your Graham factors to determine if you're going to track. And if I recall correctly, that this agency, it was, if I have 2 Graham factors, we're going to track. And then think about that. And it boils down to, at the end of the day, use everything that you know to make the best decision possible to stay legal and stay within your policy, because we all know that sometimes it's not if you're legal, it's if you were within your policy. So, don't step outside of your policy just because it's legal. Our policy is more restrictive than the law sometimes, and you just have to deal with that. And if you can't deal with it, write something up and take it to your higher ups. Be the change, and this is such a cliche, but be the change that you want to see. If you want to see something change, go research it, dig through it, find a better mousetrap, and take it to these administrators. I do think that these days in law enforcement, administrators are more than ever listening to the rank and file than they were before. They've got to keep officers, and they're really running with a lot of things that the guys and gals are bringing them. So take some interest, study up on it, and if you can't deal with it, then try to change it. If you can't change it and you can't deal with it, find an agency that you can go work for that will. But again, think about your training and think about what you can do legally and within policy. That makes sense.
Yeah, let's talk about some of those criteria. You had mentioned offline that some agencies have gone to a felony only for a track, and then other agencies have said you need 2 Graham factors. And obviously sometimes those are decisions made above your head, and I want you to talk about how those work in practice, because sometimes you're going to be wrong. Sometimes you're going to have a set of circumstances, and we'll talk about that in a second. But often people say, well, I'm not going to have an effect. I remember, because I'm old, I remember when the only reason an agency got a canine is because somebody did the research and presented it to the chief and the sheriff and the city council or the county commission, and that's how it happened. But let's talk about some of these things. I mean, how does the, and then we're going to get into Barnes versus Felix because I think this segues very well. The canine officer comes into somebody else's scenario, and often, I mean, obviously they're on patrol, but when you get called out, and I think there's a couple of things that are problematic about that. You may not know who was next to you in the track. You may not be able to reconstruct their name for your report. But the analogy that I've given in the past is I for about 18 years I represented doctors in hospitals, a little company called Wellstar in Georgia. It's the third largest healthcare system in the United States, nonprofit healthcare system in the United States. And we worked with a lot of trauma surgeons. Well, the trauma surgeons don't have patience. If you're making an appointment to go see your trauma surgeon, you're asking someone to hold your beer before you go, okay? They are treating other people's patients. So they take the patient as they find them, whether they, injured themselves voluntarily, somebody else's negligence, there was a bad outcome, a drug reaction. They have to take what they find. And in that analogy, you get called to assist another agency. What's that like to get on the scene and as the canine officer say, what's going on? Well, he ran that way. No, what do you know? How do I reconstruct those grand factors?
And that's, speaking from experience of being called away from my jurisdiction many times to go work with agencies. I might not have heard what led up to this. I might not have heard anything. I'm going in blind like a lot of you are. When you get there, I want to know a few things. I don't need to know, and I think y'all can agree, I don't need to know, the minutia. I need to know, is he violent? Did he flee? Which way did he go? All that stuff. But I want the who, what, when, where, and why so that I can construct in my brain what we're dealing with. And then the other thing I'm going to ask is, hey, have y'all already checked the car if it's somebody who fled from a car, or do we believe they have weapons? Because in the heat of the moment, we're the ones coming in. We've got to worry about our safety, the dog safety. We've got to worry about our legality. We've got to worry about our policy. Have your set of questions in mind for when you get there. Share this with the agencies that you work with on a regular basis. These are the things that I need to know, either while I'm en route or when I get there, because I'm not going to take a sucker bet and put myself and my dog at risk. Number two, I'm also not going to get myself in a sling with my own policy if I find out that this is something that we can't do because of policy. So come up with these questions, have them ready, or at least tell the agencies that you're going to and maybe get them answered if you're on their same radio channel on your way there, things like that. Because at the end of the day, again, this is your butt in the sling. And not only is it your butt in the sling, it's your dog's butt in the sling. When my dog would get into a use of force and bite somebody, I wasn't, I was worried about myself, but I was more worried about my dog and if he was going to get in trouble, which sounds dumb, but the way he gets in trouble is via me. He loves to go to work. He's not going to be able to go to work if we do the wrong thing. So let's, have those questions, ask those questions, and then compare them to what you can do legally and what you can do through policy.
And let's break for a second there because there's another important part. I have tremendous respect for law enforcement, as you know. I've represented 180 officers in shootings. I've represented canine officers, canine handlers who have had to shoot somebody who shot their dog. I mean, these are horrible situations. TAC officers, snipers, all sorts of different individuals. But as a canine officer, when you show up, as the TAC unit that shows up, you have to recognize people are going to look to you. You have to be very, very well trained and you have to be above the standard because especially when you get deployed to assist with another agency, you may be the highest tactical trained person on the scene. They literally may be looking to you because they don't have experience into what to do with this situation. And I remember just a very basic thing. I want to talk about Barnes versus Felix. Very basic thing when we first got our first canine at Cobb County Police. Canine handler went around to everyone and said how to hold a perimeter, these are the circumstances you call, and said, don't run after the person if you're going to call us. And if you do, tell us you did it. Now, that sounds very simple, but in the heat of the moment, people forget those things. So, as the handler, just remember you may very well be kind of the attack officer in charge, especially if no one else has gotten there. It's very fresh. So, let's talk about Barnes versus Felix for a second. I know you've had a chance to read it, and we're going to have a lot of information in the show notes, if you will, that'll go out. And one of the things we have is a white paper that is very good on Barnes versus Felix. We're also going to provide you the actual transcript of the oral argument before the United States Supreme Court. So, oral argument before an appellate court, and if you go on our YouTube channel, you can see me doing one before the Arkansas Court of Appeals, which is a lot of fun, and it was a tremendous honor to be able to represent an officer with Little Rock Police Department in a case that had been pending for many, many years, 6 years before getting there. Oral arguments are short, 15, 20 minutes. So the transcript is not that long, but the oral argument is an opportunity for the lawyer to have an interactive discussion with the judges who are going to make the decision. And those judges make decisions from a very different perspective. So when you have an oral argument in front of a trial judge, that judge is going to make a decision for that case, keeping in mind the facts of that case and how it will affect the litigants in front of them, whether it's the state and a criminal defendant, whether it's civil litigants. An appellate court is looking at the facts of that case and comparing it to facts generally that could be encountered by the litigants and future litigants, and saying, what should the law in this jurisdiction be? Well, when you talk about the Supreme Court, it's the entire United States. So in Barnes versus Felix, and we have the video, but the Barnes versus Felix, they were discussing this issue that was an interpretation of the totality of the circumstances from Graham. And totality of the circumstances is a big time frame. Is it 5 minutes? Is it 2 minutes? I've represented officers who got on a scene and within 30 seconds to a minute, they wound up having deadly force used against him. They shot back, and within a minute and a half, they're doing first aid on a suspect who's down. I've also been on other scenes, and Matt, I know you've been on other scenes that were hours long. So that totality of the circumstances stretches out sometimes for the better part of a day. So the Barnes versus Felix involved a traffic stop, and an officer pulls someone over because of a tag hit on a reader. And he pulled the person over. The person was acting very suspicious. They wouldn't stop moving around in the vehicle. They said they didn't have their license. It wasn't their car. It was their girlfriend's car. He opens the trunk saying, well, my stuff is in the back. And when he opens the trunk, the suspect, when the officer's attention's diverted for a second, he tries to drive off. The officer jumps on the running board of the car. The suspect jives off with him on the car, and the officer shoots him, and he's killed. Behind the officer is a concrete barrier. And when we look at that concrete barrier, and we had an officer killed in Georgia by someone running him into a guardrail. So a deadly threat was behind him. So this question came, was the officers jumping on the car, was that the moment of threat with the suspect driving away that should be examined, or the entire circumstance? So Barbara, why don't you play that video for us?
afternoon, sir. I'm Deputy Chief of the Constable's Office. The reason you're being stopped today is because your vehicle alerted to outstanding tow violation. You have your driver's license, proof of insurance with you? Sir? I understand that, but it has outstanding tow violation. When did you rent the vehicle?
About a week ago.
About a week ago?
It's actually rented my girlfriend's name. I'm actually on the way to
I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it washed and turn it back in.
Okay. What's her name?
Sorry, Alicia.
Okay. You have your driver's license?
I'm getting over this car. I'm watching the car and turning it in.
Anything in this vehicle I need to know about? That's it. Don't go digging around. I smell marijuana. Is there any marijuana in the vehicle? Don't dig around. Don't dig around. Don't dig around. Okay. Do you have anything, any identification on you? Sure, go ahead and pop the trunk for me. Okay. Go ahead and put that paper off to the side for me. Go ahead and ship out for me. Don't fucking move! Don't fucking move! Watch out, 14, shots fired! Shots fired! Let the shots fired! Let the shots fired!
So very quick, as you can see, this situation, the family filed suit in the district court in Texas. The district court said, okay, we're going to have immunity because of the moment of threat doctrine. And then the Fifth Circuit said the same thing, and then it came to the Supreme Court. So, and this really is predictable if you think about it. And if you read Graham and you've been reading all these cases, it really had to do with, well, the Supreme Court said, well, where is the line? Is it the 3 seconds before? Is it the 2 minutes before? Is it the 5 minutes before? And basically, and just to kind of tell you procedurally, and we checked this morning, nothing's been done. The case was sent back to the district court for a decision consistent with the standard. And the Supreme Court said that the moment of threat doctrine is way too restrictive. So the court has to follow the totality of the circumstances and look at everything that occurred. Now, what's interesting about this case, this is a lot of push and pull that's been going on, and it relates a lot to canines, because what plaintiffs were doing, and unfortunately what some prosecutors were doing, was saying, well, if the officer in the totality of the circumstances used better tactics or used tactics that we think would have been more appropriate, then it would have foreclosed the opportunity for the suspect to act. Now, if you think about this, we have all these circumstances the officer has to control, and now we're supposed to be able to control what a suspect does. And this really gets to the canine officer coming to the scene. And you mentioned trying to gather all the information. But remember, when you talk about a reasonable belief, the flip side of that is you can have a reasonable belief and be 100% wrong. So if you can talk a couple of seconds about how this moment of threat versus this totality of the circumstances and how those circumstances change. And especially for canine, we're not talking a 100-foot distance between your car and the suspect's car at the end of the shooting. You could be talking about a half-mile or a mile-long track, and circumstances change.
So just in where I think this is probably going to be most applicable is you're talking about a track, you're talking about somebody hiding, you're talking about somebody that's going to end up either jumping up and running, you're talking about somebody that's going to end up firing at you. You're talking about these things, and in the totality of the circumstances, you have to consider, have you been on a 2-mile track? Do you have the ability to defend yourself? Is there an argument that could be made that, well, you should have been able to handle this, you should have been able to handle that? Think about these things and use the totality of everything you know, use the suspect's behavior, because at the end of the day, the court still does hold the suspect responsible for their behavior to a certain degree. as long as we're not acting with ill will, outside just with gross negligence, you're going to be okay. But you need to think about this stuff. You need to think about how you're going to document it, who, what, when, where, and why. I just think that it's paramount, and we're lucky that we ended up in this situation with this case. But to Lance's point, it's going to come up more and more often about the officer created jeopardy and things like that. So
yeah, and let's talk about that for a second, because it's really interesting. And this is one of the reasons I tell cops, it's really interesting. Officers are supposed to be aware of clearly established law, which is amazing. I mean, I read hundreds of court opinions every month if I'm researching, or every year without a doubt. And there's some that I don't come across. So this notion that the average beat cop is reading 25 court cases that come out of the 11th Circuit every year is a fallacy. They rely on their training agencies to pick and choose what's important. But in that oral argument, two things happened that I think are very critical. One should give a lot of really good encouragement for law enforcement. The first that happened was, this is not an officer-created jeopardy case. And people have argued with me about that, and it's not an argument, because you're just wrong. Because if you read the oral argument, the court, one of the judges said, do you want us to consider officer-created jeopardy? And the lawyer for the plaintiff was kind of equivocal. He said, no, this is not an officer-created jeopardy case. And they said they might revisit it later, but it's not an officer-created jeopardy case. The other thing that's extremely important, and I believe it was Judge Gorsuch, it's a 9-0 opinion, which getting that particular Supreme Court to agree on something 9-0 is pretty impressive. But 4 judges wrote in what's called a concurrence. So they agreed with the main body of the opinion, but their rationale was so important that 4 of them got together and said, we want to express it. And it's reflective of what happened in the oral argument. Justice Gorsuch said, we need guidance for law enforcement. Your answer, Mr. Plaintiff, is, well, the officer could have let him go and get him later. That's not going to work. When a suspect flees a traffic stop, the officer is balancing a danger to the public. When the officer goes to catch them again, there's a danger to the public. So you have a United States Supreme Court justice who has security around him all the time, thinking about what guidance that court is going to give to law enforcement officers in the future. And I think that is a really good lesson for law enforcement officers to recognize that the people in those seats right now are focused on you. And I'm going to move on here a little bit. I want to make sure we have time for questions. Speaking of which, we have our Force Forum. We just had our Force Forum, and I want to personally thank the United States Supreme Court for issuing the opinion in Barnes versus Felix the Friday before we started our Force Forum. I'm sure, Matt, it was clearly designed for our seminar, but it came out the Friday before. So this is to register for the next one. The last one we did had a lot to do with we cover officer resiliency, we cover the investigation, we cover using experts, the bread and butter of how to defend officers. Again, it's open to officers, trainers, and the lawyers who represent them. 2 lawyers with about 25 years of experience each said it was the best training to defend officers they'd ever seen, and that really meant a lot to us. April 21st through the 23rd, 2026. I know we're going to make you come to the beach and eat seafood. It's a terrible thing. We all have our bear to cross. But if you can come down there and join us, we are formalizing the topics now. And this is your seminar. We always have something on officer resilience. We always have an officer there who has gone through the ringer. They've been prosecuted. They've gone through a shooting. They've been wrestling with the post-traumatic stress of the event. We always want to keep that in the forefront, but we cover case law and we cover techniques and tactics. And if there's a topic that you want us to include in this, we are still creating the agenda. So please let us know. And obviously we always have the FOP discount. The next slide I want to show you has to do with our July 10th webinar. Our July 10th webinar is about some legislative successes we had this past year. The legislative successes we had this past year were just absolutely fantastic. We got a bunch of different statutes passed. We were down at the Capitol a lot. That is Chloe Strickland's team. She's a paralegal and a law student. She works in my office. She helped us out a lot. Also, Ken Davis in my office, who's a retired cop, went to law school, valedictorian of his law school, 29 years in law enforcement. We have a great team, 9 lawyers now, 3 different cities. We spent a great deal of time down at the Capitol. And for those of you who are not in Georgia, getting legislation passed, talking to legislators is the same in every state. And if we can impart some information, impart some excitement, impart some recognition that you can make a difference, please come and listen to this seminar on the 10th. It's an opportunity. It's no cost. You can get post credit for it in Georgia. And it's an opportunity for you to really see how you can make a difference and recognize these legislators want to hear from you. When we're talking about these legislators hearing from you and having your education, you have to have your knowledge base. One of the best forms of knowledge that I've seen about the recognition of what actually occurs in a use of force situation is force science. If you are not force science certified, I highly encourage you to go to it. Bill Lewinsky, Dr. Bill Lewinsky of Force Science, and I will be at the HITS convention. And Matt, I know all the canine folks here are very familiar with HITS. Massive conference will be in Texas this year. Looking forward to that opportunity, and we'll be talking a lot of these same situations. How does the circumstance leading to the use of force by a canine change over the course of time? How do you defend it? How do you recognize the force science principles of human interactions applied to the canine? And Dr. Lewinsky's been pairing up and getting some really, really good research to help your canine officers understand this. There is no way you are getting out of a seminar with me without hearing about the Fraternal Order of Police. You can have our YouTube channel popped up there for a second. You can go to our YouTube channel and find out more about what we do. But if you are not an FOP member, the Fraternal Order of Police Legal Defense Plan, I think, is the best in the industry. It's fantastic. I've used it a lot. I'm actually a member of it because I'm still sworn. And if you go to foplegal.com, you can learn a lot more about it. Matt, a couple of closing remarks. Tell us about we talk about canine officers finding time to train. How important is it for that canine officer to take a step back and be maybe above the average street officer in their knowledge of use of force?
You should be one of the foremost, as a canine officer, you should be one of the most educated ones on use of force, because again, think of it this way. You pull the trigger on your firearm, it goes bang. You pull the trigger on your taser, it goes zap, zap, zap. You do OC, you do ASP. You control every one of those uses of force. Your partner is the one that has its own brain, lives, breathes. You have to take care of him, but at the end of the day, he's going to do what he wants to do. So one, you need to be training, and you need to step aside if your department's not letting you train, and you need to do the training on your own. Be a cut above there. Be the best one that you can be. But you need to know use of force inside and out. You need to be, just like you run through scenarios while you're going to calls. How am I going to handle it if this happens? How am I going to handle it if that happens? You need to be thinking about the same thing if you're in situations with your dog. Now, you may think of this stuff when you first get a dog. You need to think about this stuff every month, every year, every time that you're riding around, because it might not be today, it might not be tomorrow. Again, these aren't the days of where you have 20, 25 bites a year. This is, your dog may get 4 or 5 street bites a career, depending on where you're at. You may get a lot more, you may get none. We're seeing dogs now that have no street bites. And does that mean that the officer was wrong? No. Does it mean that they could have deployed their dog, but they handled the situation differently? Most likely. But don't be afraid to be that guy that your dog has no bites. At the end of the day, use your brain to deploy your dog in the way that you, after educating yourself on every bit of this stuff that we're talking about, and you go out there and you do the job the right way within the law. That's my 2 cents on that. And I do want to throw in, anytime that you see Lance, he's telling you FOP legal, and sometimes I'm sure you're like, here we go again. I can tell you from personal experience from a friend that went through this, who didn't have FOP legal, unless you have $60,000 to $70,000 in the bank, and we're talking, this is not even a deadly force case. Unless you've got $60,000 to $70,000 in the bank, if you don't kill somebody, but you might just have to deal with something else, it's a small price to pay to have that peace of mind that you can go out there, you can do your job, and that they're going to defend you to the hilt. So think about that, because that's your house going away. That's your car going away. That stress, your marriage may go away. Think about all this stuff and get the legal plan. Do yourself a favor and just bite the bullet and do it. It's not worth thinking that, hey, I'm gonna go out here, to Lance's point, you can go out here and be 100% right and you can still end up being wrong somehow. And that's what his team is for. I've known Lance for 20 plus years. He taught part of my mandate. And when I was a chief, I've used him as a lawyer. There's second to none, guys. And it's totally worth it to be able to go to work with that peace of mind, knowing that. And that's my own personal plug. Lance doesn't pay me to say that. Like, this is just $324 a year so that you don't have to spend 60 or 70,000. That, I mean, I know as police, we all make a ton of money, but $324 a year so that you don't have to spend that, and you don't have to worry about losing your house, your cars, everything. It's worth it. That's the best advice I can give you, especially if you work a K9, because again, your dog has a mind of its own. It has its teeth, and the only way it knows how to communicate is with its mouth. So think about that stuff and spend the money to get yourself protected so that you can go out there and do your job without having to worry about what if this goes sideways because of the optics of it, not the legality, just the optics. Because more than ever now, we're on camera all the time, and all it takes is one wrong move for the political tide to turn and you to end up in court, all because of the optics of it. It doesn't mean that you actually were wrong. You can get exonerated at the end. That's going to be on page 97 of the paper. You being indicted or you being brought to court is going to be on the front page. But the people,
and it's interesting. I mean, and like we said, you can have a reasonable belief and be 100% wrong on the facts. Great advice. I appreciate the confidence and the kind words. And I'm going to go ahead and wrap up. I can't believe an hour has gone by. This has been great. I want to go ahead and put our disclaimer up, and I'm going to tell you something behind it. You've got to make sure that you are prepared, not only physically, but mentally, with your education. Everything has to come to bear so you can protect yourself and your family. You spend a tremendous amount of time. I have people asking me all the time, why do you stick up for law enforcement so much? Because the bottom line is they put their lives at risk for strangers, sometimes even strangers who don't like them very much. And as long as you are doing that, as long as you are protecting yourselves, as long as you are protecting the public, as long as you're doing the right thing, then we're going to be there to protect you. I don't see any questions popping up, but if you have questions for me or for Matt, feel free to email us. We are happy to respond to you. If there's anything we can do to assist you in the future, it's pretty easy to find us. And if you are signed up for the webinar, you will get the documentation of the white papers and other materials that we have. So I'm going to sign off. I appreciate everybody joining us today. Be safe and take care of yourselves and take care of each other. Oh, we have one question that popped up. Let's see who this is. Oh, thank you. Well, Mark, happy to do it. And thank you for your comment. All right, y'all be safe. Thank you.